Hey guys, welcome to the think tank. Good to see y'all. Hello, Kiska, Adam, Mel, Mexi. Let me see here, Melissa. Good morning, everyone. So this case, guys, there's just more and more coming out. So I've got 2 more documents to go through, and they're very interesting, let me say. So, and thank you. I want to thank you for the pizzas and the coffees. Very nice. I appreciate it, Mel. I sorry I didn't thank you earlier. I hadn't even checked in there and was doing some cleanup as far as my tab went, and I was like, "Oh, wow, thank you, thank you." So more paperwork. Still kind of worried about Abby and Libby's families, you know? I haven't seen anything really come out about it. Oh, hey, Tracy. Well, good to see you. Oh, man. So before we start, let's just take a look at these girls. Like, oh my word. What the case is truly about, right? So, yeah. Let me see here. Mm. Mm, 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 mm. Sorry, guys. Sorry. I had to do some work in the back. So I got rid of the troll, guys. I'll have to check in the back again. Let me see. I'll check one more time. Okay. So hopefully that's gone. Shaboom and zap. Sorry, guys. We have problems with a certain troll that comes back. And got to make him gone before it causes trouble, right? So Abby and Libby, this is what this is about. You know, this is not about Gull. This is not about lawyers. This is all the stuff that's standing in the way of getting justice for these 2 little girls. You know, the fact that somebody has put photos out about these 2 with these 2 passed away, it's absolutely nauseating to me. I just wow. So while we're going through this, let's just remember Abby and Libby and their families, and keep in mind that this is just a sideshow happening around getting justice for these 2. It's sickening, guys. It's sickening. And the fact that it's all happening with law enforcement, equally as so. All right. So, law offices argue for reinstatement of Delphi defense attorney's dismissal of the special judge. Let's see if I can make this bigger for you. Hells yeah. Let's do that. So, 2 Indiana law offices are arguing for the reinstatement of Delphi suspect Richard Allen's attorneys and removal of the special judge, Francis Gull, in the case, according to court documents. The writ of mandamus filed on Monday morning, the Lehman Law Office and the Wynick Law Office claim attorney Andrew Baldwin's oral motion to withdraw his representation of Allen was involuntary. That motion was filed just before a scheduled hearing on October 19th, where Judge Gall announced Allen's attorneys had removed themselves from the case. Judge Gall and the court accused Allen's defense team of gross negligence stemming from their filing a motion to protect Allen's health and safety and the leak of crime scene photos by a third party. Attorney Baldwin and Brad Rozzi claim they chose the voluntary withdrawal route to avoid jeopardizing the case. But just before the October 31st hearing, Baldwin and Rozzi entered themselves as private counsel for Allen, per Richard Allen's request. However, the court said, I cannot and will not allow these attorneys to represent you with the concerns that I've had and with the gross negligence that I have found. So she has taken this completely upon herself with absolutely no time for the court for the lawyers to respond. She just went ahead and did this. And I do believe that this is one of the things that they're going to run into trouble with. The new attorneys were assigned to Allen and the trial was pushed back. So not only did she assign new attorneys, she also assigned them from a different area, not from the same county, which again is not something that they do. She didn't go through the recommended list. By the looks of things, my personal opinion, don't sue me, is that she just went up to her buddies and said, hey, I've got a job for you. So the mandamus claims that the state of Indiana only recognizes two situations where a court may dismiss a counsel against the client's wishes, and that this situation is not one of them. Lehman and Wynick request the removal of Judge Gall due to concerns over her ability to be impartial. The law offices claim Gall removed Baldwin and Rozzi from Allen's counsel based on her subjective belief that the attorneys are negligent. So let's take a look at this paperwork, friends. Alrighty. So, State of Indiana on the relation of Richard Allen, the realtor, the Carroll County Circuit of Court, and the Honorable Francis Siegel. I love that Siegel. Shithawk, beach chicken, special judge, in my opinion. RELATOR'S brief in support of the petition for writ of mandamus. So we've got this, and we've also got the response. And of course, this is all the attorneys for Relator Richard Allen, Wynick, and Lehman. Table of contents. Introduction. Okay, I need to hydrate. You guys aren't chit-chatty this morning. Just waking bacon. So, okay. I'm gonna see if I can make this one more bigger for you as well. Let's see. Done. Boom. Introduction. Over 5 years after teens Abigail Williams and Liberty German were brutally attacked in Delphi, police announced that they had arrested Richard, or Rick, Allen for the deletings, concluding a police investigation that has captured the world's attention and involved thousands of tips. At his initial hearing and clad in protective gear for his own safety, Rick told the court he would be hiring private counsel. Rick was transported to the DOC for safekeeping. The judge removed himself from the case. And a special judge was appointed. So do you guys remember at the very beginning, there was another judge, and he was worried for Richard Allen's safety. He was worried for his safety. He was worried so much that he recused himself. And this is where Special Judge Francis Gull was appointed. But a week later, Rick threw himself at the mercy of the court and requested a public defender. Andrew Baldwin and Brad Rozzi, attorneys with a combined 50 years of experience, were appointed. Over the next year, attorney Baldwin and Rozzi zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of his probable cause affidavit. They repeatedly requested a change in the conditions of his confinement due to the obvious effects the conditions were having on his physical and mental health. And they prepared a trial strategy with Rick after pouring through thousands of pages of discovery to prepare for his defense in January 2024. During that time, Rick never complained to the court about his attorneys. On the contrary, he unequivocally stated his desire to have attorneys Baldwin and Rozzi continue their zealous representation. Yet less than 3 months before the trial, the court removed attorneys Baldwin and Rozzi as counsel, citing its extrajudicial findings that counsel had engaged in gross negligence. At Rick's direction, attorney Baldwin and Rozzi entered appearances as private counsel, agreeing to continue to represent him for free, pro bono. And you know what? Let's see what I've got here. Do you remember when he showed up like this? So was this his own doing, or was actually something happening to him? I don't know the answer to that. This is how he has to go into court. He's usually covered in protective gear, as well as the people that are bringing him in. Another year. Okay, so let's see here. But at a hearing held on October 31st, 2023, the court told Rick that it had grave concerns about his defense team, that he was entitled to a vigorous defense, and that the court, this is it, cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. So what the hell is that? What the hell is that? Cannot and will not. Rick's trial has been reset for a year from now, and he has been forced to start over with new attorneys. The court's statement about Rick's counsel have completely undermined the credibility of Rick's proffered defense. Rick has an original action currently pending in this court under case number concerning the lack of public access to the court record in his case. The lack of transparency is an important societal interest, but the issue here implicates Rick's fundamental constitutional rights to counsel and a fair trial. Okay, so what do you think about this? We are going to hear back after this paperwork. So it is going to be, let me see here. Yeah, it's going to be interesting. The paperwork has got an immense amount of information in it. Kind of shocking, but I'm glad that there is a little bit of transparency that seems to be coming out, because the gag order has literally bit everybody in the butt, right? I'm going to go over here for a second, friends. Okay, so while I'm doing this, if you haven't subscribed, please do, and hit that thumb and the share button. I appreciate you. Yeah, she's gone rogue. She really, really has. That's my opinion as well. Okay. Just checking the back again, guys, making sure everything's safe. Once that troll shows up, I get a little bit nervous because It's not a friendly troll, go figure. I need to look at this. Sorry, guys. What's going on? Give me 2 seconds, friends. Hey, Dandy. Good to see you, friend. My chat was stuck. Okay. Good to see you guys. We can get into this. My chat was stuck. I couldn't see what was happening over there, and it wasn't moving, so I got a little concerned. Like I say, when the trolls get in there, I get a little concerned. Okay, so background. Rick requested and was appointed competent and experienced counsel. In October 28th, 2022, the state charged Rick with 2 counts of M. Officers arrested Rick and took him into custody, where he was remanded ever since. The Carroll Circuit Court ordered Rick transported to the DOC for safekeeping due to a toxic and harmful existence on public information from media about this case. After sending Rick to the DOC, the judge recused himself. The Honorable, Frances C. Gull accepted an appointment as special judge. She's special, all right. I'll give her that. Rick was requested a public defender to represent him. Attorneys Andrew Baldwin and Brad Rozzi were appointed as Rick's counsel. So these two are from 2 different firms, right? They are not working for the same firm. They're not. So when there was this leak that came out from Baldwin's side, I don't understand how this affected Brad Rozzi. I am not quite sure about that yet. Attorney Baldwin is one of only 4 Indiana certified as criminal trial specialists by the National Board of Trial Advocacy, as authorized under Indiana Rule of Professional Conduct 7.4. He has nearly 30 years of criminal trial experience, handling hundreds of jury trials and representing numerous defendants charged with M. Attorney Baldwin has never been disciplined or suspended. Attorney Rozzi has over 20 years of criminal trial experience, handling thousands of cases, including 8 M cases. Attorney Rozzi practices regularly in Carroll County. And this is it. These other attorneys are not from Carroll County. He was born and raised in adjoining Cass County and is intimately familiar with the police officers and prosecutors investigating and prosecuting the case. Attorney Rozzi has never been disciplined or suspended. Rick wants his partnership to handle his defense, wants this partnership to handle his defense. Rick's lawyers issued a press release affirming Rick's innocence on January. On November 29th, 2022, the charging information and probable cause affidavit in Rick's case were made available to the public. Attorney Baldwin and Rozzi issued a press release which responded to the allegations contained in the affidavit, reasserted Rick's innocence, and indicated they will continue to share exculpatory information with the public to the extent they were ethically permitted to do so. Later that day, the court entered a gag order. Yes, she did. Prohibiting parties from making extrajudicial statements about the case, which was reaffirmed after the hearing. Yes. The court also entered a protective order prohibiting the parties from divulging or granting access to the discovery material, all except certain people. And I think that means everybody. In December 21, 2022, Rick's counsel, Andrew Baldwin, inadvertently mailed a summary log of the evidence on a flash drive received during discovery. The log did not contain any substantive evidence that was familiar to the table of contents. 1C, I see. Due to his declining mental and physical health, Rick asked to be moved out of maximum security segregation confinement. And there goes my tongue tripping over everything. Okay, hello. Okay, so let's see here. On April 5th, 2023, Rick moved to modify the safekeeping order, arguing that he was unrepresented when the order was entered, that no hearing had ever been held on the motion, and he was being held in a maximum security segregation unit at Westville Correctional Facility, WCF, that is generally reserved for violent convicted offenders, and that WCF had a history of unequal and inhumane treatment of its inmates. Rick described the conditions in which he was being held, as well as the obvious decline in his physical and mental health. Rick explained the significant hardship his placement in WCF had on his ability to assist his attorneys in preparing his defense. The court denied the motion, reaffirmed its prior order, and clarified that the DOC could move Rick to accommodate his needs. Attorney Rozzi filed a tort claim notice to preserve Rick's right to obtain private counsel in the future, to file a civil suit relating to the conditions of his DOC confinement. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defense of third-party guilt. Rick's counsel continued to file motions to change his confinement conditions. He and his attorneys also developed a trial strategy of seeking a speedy trial and pursuing a defense of third-party guilt. Several months before the trial, Rick filed motion to suppress evidence, a motion in Lemine regarding the ballistics evidence, and a request for a hearing under Franks versus Delaware. Rick also signed a motion for speedy trial, which Rick's attorneys planned to file in early November to lock in the January trial date. During a telephone conference with the court in early October 2023, Rick's attorneys informed the court that they were ready to proceed to the trial in January. The trial court removed Rick's chosen counsel over his objection. In August 2023, a former employee of Attorney Baldwin's office, Mitchell Westerman, stopped by Baldwin's office for a visit. Westerman slipped into the conference room where he found crime scene photos, and by his own admission, we looked at this yesterday, secretly photographed some of the materials and disseminated it. Attorney Baldwin was not aware Westerman had done this. When counsel learned that the material had been disseminated, they disclosed the matter in an email to the court and the state on October 6th. The prosecutor responded that he had known about the leak for a day and the state was investigating the matter. On October 9th, 2023, Westerman told Attorney Baldwin about his inappropriate, if not criminal, what do you guys think? Is probable? I would say so. How is that not like illegal? Why? It's sad because his lawyers are paying for what this dick did. What this dick done. Rick's counsel informed the state, the court, the following day. The parties had a telephone conference with the court that day to discuss the matter, and the state mentioned the issue of disqualifying counsel. A day later, counsel informed Rick of the matter, and Rick immediately and unequivocally indicated he still wanted his attorneys to represent him, believing their representation was in his best interest. This letter was filed with the court on October 12, 2023, as an attachment to the letter filed by attorney Rozzi. After receiving Rick's letter, the court notified the parties that it was scheduling a hearing on October 19th, 2023, to address other matters which have recently arisen, and ordered Rick's counsel to cease work on Alan's case until they meet on the 19th. On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 p.m. before the hearing to discuss what was expected at the hearing. Attorney Baldwin filed a memorandum regarding possible disqualification or sanctions, explained the circumstances regarding the theft of discovery, the law regarding a criminal defendant's constitutional right to counsel, the court's limited authority to remove appointed counsel, and proposed sanctions in the event it was warranted. On October 19th, 2023, the judge opened the courtroom to the media and for the first time authorized 1 or 2 cameras providing pool coverage to be permitted in the court session. The attorneys appeared in chambers without Rick being present. During the conference, the trial court read a prepared statement to Rick's. See, this is it. She had something ready. She knew what she was doing. She accused them of gross negligence and cited specific examples of their advocacy and purported acts of their negligence. These purported acts of gross negligence included the following: issuing a press release before entry of a gag order, filing motions to protect Rick's health and safety, which the court believed lacked evidentiary support, unintentional emailing of a discovery log to a third party, unspecified improper statements made in the motion to suppress, filing a tort claim notice to preserve Rick's right to seek readdress for conditions of his ongoing confinement, Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification, and a third party impermissibly photographing discovery without the knowledge or consent of either lawyer. So this is what she says she's got. How are you guys doing over there? Everyone doing good? What do you think of all this, friends? How's it going? Okay. What do you guys? It's all very dodgy, just dodgy. I agree. Alrighty. Then the court informed Rick's attorney that they had 2 options: voluntary withdraw their appearance or be disqualified as counsel after the court read its prepared statement in open court. So is that not a threat, guys? It is, Mal. It's a complete mess. It really is. Are we talking about Chatter the case? Both is a mess right now. Oh, my word, you kids, I tell you. Okay, so attorney Baldwin and Rozzi met with Rick to discuss the matter. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel. Right, Mel? So Rick's attorney informed the court that they believed the court had engaged in unconstitutional ambush of Rick and his counsel without due process. So I'm not a lawyer, but she She did not do anything to include them. She didn't hear anything. How do I put this? There's no paperwork. There is no paperwork. There is no due process. It's like she thinks she's the boss of, I heard Michelle say it, the boss of the world, that she has absolutely nobody to be accountable for. That's kind of what I'm seeing, I do believe. I don't, ethically, I don't believe this woman needs to be there. But I'm not living in that state. I'm Canadian for that much matter, and I have no say, but I'm just seeing something go extremely sideways. My heart is still going out for those families, and it's an ish show. It's a complete ish show. So that's my opinion. Here we go. Counsel also informed the court that they believed their withdrawal was involuntary and done under duress, since their refusal to withdraw would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence. It cast Rick and his attorneys and the merits of his defense in a negative light. Such a public statement risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating actual conflict for their continued representation. Faced with this dilemma, attorney Baldwin orally moved to withdraw his appearance, and attorney Rozzi informed the trial court he would file a formal motion to withdraw his appearance later that date. Okay, so the court reporter declined to provide a transcript. So do you guys remember this? We went over this yesterday, where they were having a hell of a time. So the court reporter declined to provide a transcript of the in-chambers proceedings, and the court did not rule on the realtor's motion for the transcript. Realtor is relying upon the recollection of Rick's attorneys memorialized shortly after the proceedings. Motion to withdraw his appearance at a later date. Attorney Rozzi did not withdraw. It just seems to me she's doing a lot of assuming. It's heartbreaking. Oh, wow. Thanks, Mel. Much appreciated, friends. Yeah, absolutely. Much appreciated. Much appreciated. Okay, so let's see here. What are you guys thinking? Oh my God, best mods ever, right, Mel? Absolutely. I can't disagree. And chat, you know, we all appreciate you. You know, you guys literally are what makes the channel. I just bring this to you, and it's you good people in the chat that keep this going. You are my motivation. And I can't tell you, I appreciate you so, so very, very much. All righty. Hydration and back at it. Uh-oh. Okay, I understand where you're saying, Tradam. Light and love, friend. Keep smiling. Keep smiling. You got this. Okay, so the judge entered the courtroom, went on the record without Rick or his attorneys being present, and stated there was an unexpected turn of events and that Rick's lawyers had withdrawn from the case. The court concluded the hearing by nothing. The court concluded the hearing by nothing, that the state had some witnesses here that came earlier to have the hearing, but clearly this is out of our control. I'm going to read that again. The court concluded the hearing by noting that the state had some witnesses here that came earlier to have the hearing, okay? But clearly this is outside of our control. In a written order, the court noted that Rick's pretrial motions were still pending due to the court still reviewing the exhibits submitted by counsel. Dandy, you guys are doing that like professionals. I am so impressed. Yeah, I agree, Maxie. So to continue pursuing Rick's trial strategy, counsel remained in the case as private counsel, but court disqualified them. So again, this is something that we don't know. Money sign gone. I don't know if you guys are needing help from me or not. Is everything going good? So, okay. Attorney Rozzi filed a notion. Filed a notice indicating that Rick did not want him to withdraw as counsel. This notice informed the court that there were no circumstances under Rule 116 of the Indiana Rules of Professional Conduct which warranted the withdrawal of counsel, and that everything cited by the court as alleged gross negligence was a product of ethical lawyering in the best interests of the client, defense, and mental and physical well-being. He did look like shite. Like, I don't know. I'm undecided if I don't know. Did he put himself into this shape? Did he do this to himself because is this like some kind of plan for sympathy? Or is it that bad? I just can't see his lawyers allowing him to go in like that. But they did, and yet they did. Dandy. The notice also indicated that Rick was asserting his constitutional right to the counsel of his choice and wanted counsel to move forward with the representation of defendant Allen until a final disposition in this matter. Finally, the notice indicates that Rick was prepared to go to trial on January 8th, 2024, and any continuance of the trial beyond that date would prejudice him. Rick, by counsel, also filed a motion seeking the special judge's recusal. The trial court ordered the clerk to remove Rick's filings from the record because Attorney Rozzi was no longer counsel of record. The court also appointed 2 public defenders to represent Rick. And do you know what was interesting is Baldwin and Rozzi sat right beside Rick, and her new lawyers sat in the bench behind them. Attorney Baldwin filed a motion requesting the courts reconsider her order to remove he and Rozzi as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion to withdraw was involuntary. The court rules outlining the proper procedures to withdraw as counsel were not complied with. He and Attorney Rozzi were not disqualified and remain as counsel of record at the time they filed a motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in the case until the motion to recuse was resolved. The court lost jurisdiction to take any further action in this case until the motion to recuse was resolved, and removal of the counsel interfered with their attorney-client relationship and prejudices Rick's constitutional right to counsel. The day before the hearing scheduled on October 31st, 2023, Attorney Baldwin and Rozzi entered their appearance as Allen retained counsel in their appearances. Baldwin and Rozzi reasserted their brief that they were improperly removed as counsel of record, and they were now entering their appearances as private counsel in order to protect Allen's constitutional right to a fair and speedy trial and to honor his 4th, 5th, and 6th Amendment rights. So with all of this, guys, ooh la la. Oh, thank you for that, Mexi. Thank you. Welcome, Melissa. Welcome. Melissa. I'm going to change the name once I can to Franky's friends, because that's what you guys are. You're all my friends. Oh, thank you again. Nice. Thank you so much, Maxie. There you go. Nice. Welcome, welcome. So on October 31st, 2023, a hearing was held. Attorney Baldwin stated that Rick had asked them to represent him. So they re-entered their appearance. The court asked what had changed in 12 days since they had chosen to withdraw. Rather than be removed, Attorney Rozzi argued that their withdrawal as counsel was involuntary so as to avoid prejudicing Allen's defense by allowing the court to disqualify them. He also argued that Rick had constitutional right to counsel of his choice, and he asserted that right and the court had no authority to remove his counsel without due process. Oh, the Motley Crew. I love it. I love it. Welcome, Perry. Good to see you, friend. The state indicated it agreed with the court that Rick's counsel were grossly negligent. What? Attorney Rozzi argued that their withdrawal of counsel was involuntary so as to avoid prejudicing Allen's defense by allowing the court to disqualify them. He also argued that Rick had a constitutional right to counsel of his choice. He had asserted that right, and the court had no authority to remove his counsel without due process. The state indicated it agreed with the court and that Rick's counsel were grossly negligent. The state reiterated the examples of negligence the court had noted during the in-chambers hearing. The court acknowledged that Rick had chosen attorneys Baldwin and Rozzi as counsel, but refused to recognize them as counsel, stating, "I have grave concerns, Mr. Allen, about their representation of you. The previous findings by this court of their gross negligence, Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case, and this is difficult, Mr. Allen, because I know what you want. You've indicated through your attorneys, but I cannot and will not allow these attorneys to represent you with the current concerns that I have had. With the gross negligence that I've found, they withdrew rather than be found grossly negligent and removed. I can't do it, sir. I just can't. I cannot allow that." Unreal. So does she have this right? She sure thinks so, doesn't she? Oh, nice. Thank you so much, Tracy. I appreciate the support. Thank you. Yeah, where are those findings, Siegel? Where? Yeah, with the BAM. Thanks, Tracy. Much appreciated. You guys are awesome. Every single one of you. So thereafter, the new attorneys requested a continuance of the January 2024 trial. The court granted the request and set it again for October 2024 trial date, noting that counsel had not yet received the discovery and were unable to estimate when they would be ready for trial. The new attorneys admitted they could not tell the court with any certainty that they would be ready in October. This is the thing. They're even saying October might be too early. Like, what the hell is that? The court also noted it had not completed review of the exhibits related to the Franks motion, and that once new counsel had time to review the discovery and the pleadings, they could either adopt those pleadings or make your own. Grounds for writ of mandamus. The trial court lacked any authority to remove Rick's entire defense team over his objection and based on a summary finding of gross negligence. Original action, provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. And then they start naming case laws. The court routinely relies on its original jurisdiction to address claims that the attorneys have been inappropriately disqualified or they should have been disqualified, and some more case findings. Here, trial court has an absolute duty to reinstate Attorney Rozzi and Baldwin and remedy on appeal its non-existence. The Sixth Amendment to the U.S. Constitution provides in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel embraces not only the assistance of counsel, but the reasonable opportunity to secure counsel of one's own choice. So again, she has taken that right away from him. And again, like I said, I don't know enough about these laws, but it does seem to me that everything that I'm reading, it's saying that he does have the right to keep these lawyers if he so chooses, and he does so choose. I almost feel, I don't know. I almost feel, somebody gets so much power and their head gets away from them. Has her head got away with her? Does she think that she never has repercussions because she's a special judge? Ooh la la, guys. Ooh la la. I don't think RA ever waived his right to a speedy trial, so another 8 months in prison definitely is not fair. I agree, Maxie. The attorney-client relationship, once established, is inviolate, and should not be served to subject to unwarranted interference. Case law. The attorney-client relationship is afforded the same venerable protections whether the lawyer is a public defender, acting pro bono, or privately retained. Indiana recognizes only narrowly circumcised, no, not circumcised, circumscribed. Sorry, guys. Oops. Okay. Right. Oh, my word. Welcome, Charlotte. Good to see you. Yeah, circumscribed, not circumcised. Situations where a trial court may sever the attorney-client relationship against their client's wishes. The lawyer is not a member of the state bar. The lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. So they're none of this stuff, are they? No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or even grossly negligent. And courts across the country regularly issue extraordinary writs in criminal cases to reinstate defense attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. And again, a bunch of case laws. When a court believes it possesses objective evidence to support a lawyer's removal, it should clearly articulate the evidence on record and exhaust other possible remedies before resorting to the removal of counsel, such as censure, disciplinary referral, or contempt proceedings. Ever considered by a judge should be and the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice of an opportunity to be heard and why the attorney-client relationship should be severed. Here, the judge acted to terminate the attorney-client representation when she had an absolute duty to refrain from doing so. This court should mandate attorneys Rozzi and Baldwin be immediately reinstated. Attorneys Baldwin and Rozzi were active members of and in good standing with the Indiana bar, and there is no conflict of interest even alleged between Rick and his attorneys. The inquiry should end there. But attorneys Baldwin and Rozzi were removed because the trial court disagreed with their conduct. The trial court made a sua sponte, I don't know what that is, summary finding in chambers of gross negligence after the state raised the issue of disqualifying them. It is entirely unclear from the record what the court found was gross negligence. The record only includes attorneys Rosley's recollections of the acts mentioned by the court because Rick has been unable to obtain a transcript of the in-chamber proceedings. Nevertheless, the judge's subjective allegations of gross negligence fall into two categories. One, a mere disagreement with zealous defense tactics, or two, concerns about an unattended release of evidence which objectively had no effect on the lawyer's ongoing effective representation of Rick. A Sixth Amendment interference with counsel claims is at its zenith whether a trial court dismisses a lawyer because it disagrees with its competent advocacy. That is precisely what occurred here. Once attorney Rozzi and Baldwin were appointed and became Rick's counsel, the court lacked the authority to obstruct and sever that relationship. If the court found their conduct upsetting or negligent, it should have clearly articulated that evidence on the record and exhausted other possible remedies before removing them from the case, such as censure, disciplinary referral, or contempt proceedings. She had an absolute duty to refrain from obstructing and severing the relationship, especially where attorney Baldwin and Rozzi suggested a remedy in the event of the court was considering removal. The court should grant emergency relief and reinstate attorney Rozzi and Baldwin. But reinstatement of Rick's counsel of choice is not sufficient to remedy the violations here. Rick was pursuing a speedy trial and third-party guilt strategy. He intended to file a speedy trial request in early November, but the judge kicked them out of the case, rejected their appearance, and struck their pleadings. The court is the only court in the state that can order a speedy trial date. If it does not seize that opportunity now, it will be forever lost. There is no post-judgment remedy available. The new lawyers have already indicated they will not be prepared for a speedy trial. A new judge should also be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. A judge shall disqualify herself in any proceedings in which the judge judges' impartiality might reasonably be questioned, including circumstances where the judge has a personal bias or prejudice concerning a party or parties' lawyers or personal knowledge of the facts that are in dispute in the proceedings. Indiana Judicial Conduct Rule 2.11A1, the commentary to this canon provides that under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. Here, the judge I can't say it right now, my tongue's not going to do it, found that counsel were grossly negligent and publicly proclaimed that she has grave concerns about their representation. The judge also emphatically stated that she could not allow them to remain as Rick's counsel, given her concerns about their representation. For many Hoosiers, this case marks the first time they have ever followed the workings of an Indiana court. Yet for all rulings going forward, the public will question the judge's impartiality. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. Conclusion: to ensure that going forward, Richard Allen receives his fundamental right to counsel, a writ of mandamus is appropriate to reinstate attorneys Baldwin and Rozzi as court-appointed counsel, to set the date of trial within 70 days from the issuance of the writ, and to remove the special judge and appoint a new one. And you've got lawyers Lehman and Wynick, attorneys for Realtor Richard Allen. Oh my word. Unreal. What do you guys think? So let's see here. So we've also got the brief of amicus curiae, I think it's pronounced, in support of the Realtor's petition for writ of mandamus. This is basically the response that we're going to look at next. A lot of reading today. You guys doing okay out there? Learning lots? Okay, and we're back. I love this paperwork we're seeing from defense attorneys, just hitting people with facts according to the law. Defense attorneys don't get enough credit. They're the ones always trying to uphold the Constitution. I'd have to demand a new courthouse judge, attorneys, jury, the whole works. Absolutely. Yep, absolutely. All righty. So once again, if you're new to the channel, subscribe, hit that thumb, and share. I'll say it 3 times in one video, and I'll not say it at all in another. So, So this is a little bit shorter. This one's only 12 pages. The last one was 21. Yeah, I'd be there too, Maxie. I'd be there too. I dug out the passport. I'll have to make sure if that they're still up to date. I don't know if they make new ones or not, but I'll make sure I've got the current one. And you'll see Franky like, what? Jumping into the Durango and off to the US I go to. God only knows where. Come on, girls, we're going on a road trip. Mom wants to be in Delphi today. Just a sad state of affairs. They really want her out of there. They just want her gone. And I think everybody else does too. I mean, I'm sure there's a few people out there that think that she's doing a great job. I'm just not one of them, you know? And what about the families, guys? You know, Mike and Becky Patty. This is Libby's grandparents. They were raising her up. And I mean, ultimately, the question's going to be, is he bridge guy? So I did bring up a picture I wanted to show you guys because it's how many people, okay, he's not a very big guy. He's like 5'4", something like that. He's not a very big guy. And you can tell in this picture he's not very big. Why is nobody mentioning a guy this size, seeing him on the bridge? The only one we've heard of was 5'10" and young. Well, he's definitely not either one of those. I really hope we don't find that someone else's bridge guy. It's scary. It's very scary. Somebody could be around that's guilty running around the streets right now. Like, how is nobody said? Because there was a few people on that path that day. Why did no one mention a 5'4" man? That one really baffles me. It's the worst. Is he bridge guy? Is he bridge guy? Indiana Public Defender Council, IPDCS. Mission is to improve legal representation provided at public expense in Indiana State Court. This mission is fulfilled in part by providing research training, consultation on strategy and tactics. IPDC is also mandated to assist in the coordination of the duties of the attorneys engaged in the defense of indigents at public expense and maintain liaison contact with study commissions, organizations, and agencies of all branches of local, state, and federal government that will benefit criminal defense as part of fair administration of justice in Indiana. IPDC is well positioned to address the importance. I'm going to make this bigger again, guys. Oh. Alrighty. That's as far as I can go. Okay, IPDC is well positioned to address the importance of independence of the defense function, a topic at the core of the work it does. IPDC's interests are aligned with the realtor Richard Allen in raising concerns about the removal of his court-appointed counsel. However, this brief intentionally focuses narrowly on independence concerns. The council is committed to support appointed counsel, whoever that may be, as the case continues. Summary of the argument. Indiana has long been a leader of providing appointed counsel and in recent decades has made strides to preserve counsel's independence from the judges before whom they appear. The removal of appointed counsel for broad or vague reasons undermines the independence of the defense's function and extinguishes a long-standing rapport with a client who must now languish in prison for an additional 9 months. Moreover, the removal of counsel, replacement counsel, should have amicus brief of the Indiana Public Defender Council, being selected accordingly to the Carroll County Plan from a list of qualified attorneys approved by the county's Public Defender Board, or by referral to the state public defender for selection of replacement counsel. Appointing counsel from Allen County, especially chief public defender of that county, deprives Indiana's third largest county of the leader of its public defender offices and raise the prospect of loss of reimbursement for Allen County if commission standards are not met. This case raises significant concerns about the independence of defense counsel and the public defense structures aligned to ensure it. The removal or replacement of appointed counsel must occur in a manner that ensures the independence of counsel. IPDC is also concerned that the removal does not undermine the public defender structure in both Carroll County and Allen counties. Indiana has been a leader in public defense and the independence of defense counsel. In many ways, Indiana has been a leader in providing presentation to those unable to afford counsel. For example, more than a century before case law, this court held that the indigent criminal defendants had a right to counsel provided at public expense. For most of Indiana's history, trial judges appointed counsel that required their compensation from the county treasurer. But a deep and persistent concern was a lack of defense counsel's independence from the court, because defense counsel's employment relied on the amicus brief of the Indiana Public Defender Council. It was thought that counsel might be reluctant to represent his or her client as vigorously as necessary for fear of alienating the judge. The American Bar Association, among other groups, has long emphasized the critical importance of public defender independence, the very first of ABA's 10 principles of a public defense delivery system, which provides guidance on how to create a well-functioning, constitutionally sound public defense system, is that the public defense function, including the selection, funding, and payment of defense counsel, independent Indiana Task Force of Public Defense findings and recommendations to the Indiana Public Defender Commission, available, and then they give the link. Under this principle, the public defense function should be independent from political influence and subject to judicial supervision, only in the manner and to the same extent as retained counsel. This court traced the history of Public Defender Commission. Okay. In capital cases, most of which were adopted by this court in Indiana Criminal Code, 1993. Okay, and it's giving as noted in Johnson, trial courts retain some ability to appoint counsel outside the county's comprehensive plan in limited circumstances. Appointments outside the approval plan may affect the public ability to seek reimbursement from the commission. First, under Indiana Code section, a judge may appoint counsel outside the plan when the interests of justice require. A court may also appoint counsel to assist counsel provided for under the board's plan as co-counsel when interests of justice require. However, expenditures outside the plan are not subject to reimbursement. So I think what they're saying is, how the heck are they going to pay them? They're in a different county. What the hell is going on here? I mean, I could be wrong. Easily. ABA's 10 principles have been updated since this court decided Johnson. They now provide that public defenders should be subject to judicial authority and reviews only in the same manner and same extent as retained counsel of the prosecuting agent and its lawyers. They've got them all down here, the 10, on that link if you guys want it. IPDC is unaware of the removal of an Indiana prosecutor under circumstances of alleged gross negligence. Public defenders deserve the same treatment as prosecutors by Indiana trial courts. Abso-frickin-lutely. Counsel was replaced without regard to Carroll County's comprehensive plan. The independence concerns raised by removing appointed counsel are exasperated when the process for selection of replacement counsel fails to follow the statutes and structures designed to protect the independence of counsel, the defense counsel. Carroll County is a member of the Public Defender Commission and has Public Defender Board and Comprehensive Plan. The commissioners of Carroll County adopt an ordinance created a Public Defender Board in 2000. The county's plan provides for an assigned counsel system under this appointed system. 1. The board shall gather and maintain a list of attorneys qualified to represent indigent defendants. And 2, upon the determination by a court that a person is indigent and entitled to legal representation at public expense, the court shall appoint an attorney to provide the representation from a list of maintained by the board. And these 2 that she has in here are no. They're from a different county. She did not follow any of the procedures. It just appears to me she decides what she's going to do, and that's what she does. Later sanctions provide for payment and reimbursement of expenses. Here, it's unclear why the respondents appointed counsel in a manner inconsistent with Carroll County's comprehensive plan immediately after announcing that Mr. Baldwin had orally moved to withdraw and that Mr. Rozzi would be filing a written motion to withdraw. The respondent stated, "I will reach amicus brief of the Indiana Public Defender Council." Out to public defenders to make that appointment. Volume 2, page 6. If no qualified Carroll County attorney was able to take this case, the preferred procedure would have been for the respondent court to take the state public defender for selection of replacement counsel. Not only would this allow reimbursement in what will likely be an especially long and expensive proceeding, but it would also better ensure the independence by insulating the selection from control by the judge presiding over the case. Public defense in Allen County is also affected. Instead, the respondent reached out and chose 2 lawyers from Allen County, neither of which are on the Carroll County list, and one of whom is currently serving as the chief public defender in Allen County. Thus, in addition to jeopardizing the possibility of reimbursement for Carroll County, the appointment of Mr. Librato deprives Indiana's 3rd largest county of the leader of its public defender's office and raise the prospect of loss of reimbursement for Allen County if commission standards are not met. Mr. Allen and the public paying for his defense deserve better. As a final point, although this brief focused on statutes and procedures designed to protect the independence of defense counsel, we should not lose sight of the person most affected. Public defenders do extraordinarily life-changing work every day in courtrooms around the state. Mr. Allen was pleased with the work of his initially appointed public defenders. Mr. Allen and the public that funds his defense would be entitled to more than a vague and broad concern about gross amicus brief in the Indiana Public Defender Council. Negligence that the judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. So this was on volume 2, page 26. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that appointed counsel is not a real lawyer but a public pretender, or a lawyer who works for the state when followed. The statutes of decisional law outlined above provide some means to dispel these misconceptions. When not followed, the trust and rapport developed during the full year of intense representation is lost, and Mr. Allen is left to wait 9 additional months incarcerated in the Department of Corrections under conditions that he and his counsel of choice have stated undermine his ability to prepare for his defense. The conclusion: the issue presented in this case justify the intervention of this court at this stage to preserve the independence of defense counsel, and the integrity of the public defense structures established by the General Assembly. The court can uphold these essential values by reinstating Mr. Allen's initial and desired counsel. In the alternative, the court should direct the respondent court to follow Indiana Code by referring this case to state public defenders for selection of counsel. And this is showing that it was forwarded to Francis Gull, Robert Cliff Scrammon, William Santino Labrado, Nicholas Charles McClelland, Theodora Rokita, Mark K. Lehman, Kara Schaefer Wenke. What do you think, guys? What the hell is going on in Delphi? It's crushing. There is so much going on. Who was it that said earlier? I mean, just start it over. They have to figure out something that's humane as far as Richard Allen, but oh my God. So yes, this was written by one of the head people in the public defender's office, as Mexi was just pointing out. I didn't go through all the case laws because I mean, I don't understand most of it anyways when they start getting into legal jargon. I don't have that education. Yeah, you're right. If it says anything, they are not pleased. Does he look like these guys? What do you think? Is he either one? What's your opinion? So the battle continues. Tomorrow is the last day for any paperwork to get into the Supreme Court. And then I imagine they'll go from there. But tomorrow was the date that was given for all the paperwork to be in. And Gull, she got an extension. I know she had problems. Well, she was turned down by, she had gone to the government and asked for a lawyer, and they said, well, no. So I'm not sure if that's just normal, if they were, I don't really know what's behind that. I thought this was interesting. That's Richard Allen's house. I don't know if they sold it. This house is absolutely not too far from the High Bridge. He does look like a villain. Yes, there is. There is Mexi. So, guys, I'm going to leave it there. That is the newest documentation that's come out. Let's not forget about these little girls and the disgusting human that actually released these photos. Let's just think of Abby and Libby. So, guys, thank you very much for being here with me. I appreciate you. You know I do. And I'll see you guys in the next one. Bye.